The Statute of Anne, also known as the Copyright Act 1709, is an act of the Parliament of Great Britain passed in 1710, which was the first statute to provide for copyright regulated by the government and courts, rather than by private parties. Prior to the statute's enactment in 1710, copying restrictions were authorized by the Licensing of the Press Act 1662. These restrictions were enforced by the Stationers' Company, a guild of printers given the exclusive power to print, and the responsibility to censor, literary works. The censorship administered under the Licensing Act led to public protest, as the act had to be renewed at 2-year intervals. Authors and others sought to prevent its reauthorization. In 1694, Parliament refused to renew the Licensing Act, ending the stationers' monopoly and press restrictions. Over the next 10 years, the stationers repeatedly advocated bills to reauthorize the old licensing system, but Parliament declined to enact them. Faced with this failure, the stationers decided to emphasize the benefits of licensing to authors rather than publishers, and the stationers succeeded in getting Parliament to consider a new bill. This bill, which after substantial amendments was granted royal assent on 5 April 1710, became known as the Statute of Anne due to its passage during the reign of Queen Anne. The new law prescribed a copyright term of 14 years, with a provision for renewal for a similar term, during which only the author and the printers they chose to license their works to could publish the author's creations. Following this, the work's copyright would expire, with the material falling into the public domain. Despite her period of instability known as the Battle of the Booksellers when the initial copyright terms under the statute began to expire, the Statute of Anne remained in force until the Copyright Act 1842 replaced it. The statute is considered a watershed event in Anglo-American copywriter history, transforming what had been the publisher's private law copyright into a public law grant. Under the statute, copyright was for the first time vested in authors rather than publishers. It also included provisions for the public interest, such as a legal deposit scheme. The statute was an influence on copyright law in several other nations, including the United States, and, even in the 21st century, is frequently invoked by modern judges and academics as embodying the utilitarian underpinnings of copyright law. Background: with the introduction of the printing press to England by William Caxton in 1476, printed works became both more common and more economically important. As early as 1483, Richard III recognized the value of literary works by specifically exempting them from the government's protectionist legislation. Over the next 50 years, the government moved further towards economic regulation, abolishing the provision with the Printers and Binders Act 1534, which also banned the import of foreign works and empowered the Lord Chancellor to set maximum pricing for English books. This was followed by increasing degrees of censorship. A further proclamation of 1538, aiming to stop the spread of Lutheran doctrine, saw Henry VIII note that "sundry contentious and sinister opiniones have by wrong teaching and naughty books increased and grown within this his realm of England," and declared that all authors and printers must allow the Privy Council or their agents to read and censor books before publication. Stationers' Company. This censorship peaked on 4 May 1557, when Mary I issued a royal warrant formally incorporating the Stationers' Company. The old method of censorship had been limited by the Second Statute of Repeal, and with Mary's increasing unpopularity the existing system was unable to cope with the number of critical works being printed. Instead, the royal warrant devolved this power to the company. This was done by decreeing that only the company's publishers could print and distribute books. Their wardens were given the power to enter any printing premises, destroy illegal works and imprison anyone found manufacturing them. In this way the government harnessed the self-interest of the publishers to the yoke of royal incentive, guaranteeing that the company would follow the rules due to the economic monopoly it gave their members. With the abolition of the Star Chamber and Court of High Commission by the Long Parliament, the legal basis for this warrant was removed, but the Long Parliament chose to replace it with the Licensing Act 1662. This provided that the company would retain their original powers, and imposed additional restrictions on printing. King's messengers were permitted to enter any home or business in search of the legal presses. The legislation required renewal every 2 years, and was regularly reapproved. This was not copyright, as is normally understood. Although there was a monopoly on the right to copy, this was available to publishers, not authors, and did not exist by default. It only applied to books which had been accepted and published by the company. A member of the company would register the book, and would then have a perpetual copyright over its printing, copying and publication, which could be leased, transferred to others or given to heirs upon the member's death. The only exception to this was that, if a book was out of print for more than 6 months and the publisher ignored a warning to make it available, the copyright would be released and other publishers would be permitted to copy it. Authors themselves were not particularly respected until the 18th century, and were not permitted to be members of the company, playing no role in the development or use of its licenses despite the company's sovereign authority to decide what was published. There is evidence that some authors were recognized by the company itself to have the right to copy and the right to alter their works. These authors were uniformly the writers of uneconomical books who were underwriting their publication. The company's monopoly, censorship and failure to protect authors made the system highly unpopular. John Milton wrote a Rea Pagitica as a result of his experiences with the company, accusing Parliament of being deceived by the fraud of some old patentees and monopolizers in the trade of bookselling. He was not the first writer to criticize the system, with John Locke writing a formal memorandum to the MP Edward Clarke in 1693 while the Licensing Act was being renewed, complaining that the existing system restricted the free exchange of ideas and education while providing an unfair monopoly for company members. Academic Mark Rose attributes the efforts of Milton to promote the bourgeois public sphere, along with the Glorious Revolution's alterations to the political system and the rise of public coffee houses, as the source of growing public unhappiness with the system. At the same time, this was a period in which clearly defined political parties were taking shape, and with the promise of regular elections, an environment where the public were of increasing importance to the political process. The result was a developing public sphere, which provided the context that enabled the collapse of traditional press controls. Lapse of the Licensing Act. The result of this environment was the lapse of the Licensing Act. The committee reported in January 1695, and suggested the renewal of the Licensing Act. This was included in the Continuation Bill, but rejected by the House of Commons on the 11th of February. When it reached the House of Lords, the Lords re-included the Licensing Act, and returned the bill to the Commons. In response, a second committee was appointed, this one to produce a report indicating why the Commons disagreed with the inclusion of the Licensing Act, and chaired by Edward Clarke. This committee soon reported to the Commons, and Clarke was ordered to carry a message to the Lords requesting a conference over the Act. On the 18th of April 1695, Clarke met with representatives of the Lords, and they agreed to allow the Continuation Bill to pass without the renewal of the Licensing Act. With this, the Lords' decision heralded an end to a relationship that had developed throughout the 16th and 17th centuries between the state and the Company of Stationers, ending both nascent publishers' copyright and the existing system of censorship. John Locke's close relationship with Clarke, along with the respect he commanded, is seen by academics as what led to this decision. Locke had spent the early 1690s campaigning against the statute, considering it ridiculous that the works of dead authors were held perpetually in copyright. In letters to Clarke he wrote of the absurdity of the existing system, complaining primarily about the unfairness of it to authors, and t. He parallels between Locke's commentary and those reasons presented by the Commons to the Lords for refusing to renew the 1662 Acta, striking. He was assisted by a number of independent printers and booksellers, who opposed the monopolistic aspects of the Act, and introduced a petition in February 1693 that the Act prevented them from conducting their business. The developing public sphere, along with the harm the existing system had caused to both major political parties, is also seen as a factor. The failure to renew the Licensing Act led to confusion and both positive and negative outcomes, while the government no longer played a part in censoring publications, and the monopoly of the company over printing was broken. There was uncertainty as to whether or not copyright was a binding legal concept without the legislation. Economic chaos also resulted, with the company now unable to enforce any monopoly. Provincial towns began establishing printing presses, producing cheaper books than the London booksellers. The absence of the censorship provisions also opened Britain up as a market for internationally printed books, which were similarly cheaper than those British printers could produce. Attempts at replacement. The rejection of the existing system was not done with universal approval, and there were ultimately 12 unsuccessful attempts to replace it. The first was introduced to the House of Commons on the 11th of February 1695. A committee, again led by Clarke, was to write a bill for the better regulating of printing and the printing presses. This bill was essentially a copy of the Licensing Act, but with a narrower jurisdiction. Only books covering religion, history, the affairs of the state or the law would require official authorization. 4 days after its introduction, the stationers held an emergency meeting to agree to petition the Commons. This was because the bill did not contain any reference to books' property, eliminating their monopoly on copying. Clarke also had issues with the provisions, and the debate went on until the end of the parliamentary session, with the bill failing to pass. With the end of the parliamentary session came the first general election under the Triennial Act 1694, which required the monarch to dissolve Parliament every 3 years, causing a general election. This led to the «golden age» of the English electorate, and allowed for the forming of two major political parties, the Whigs and Tories. At the same time, with the failure to renew the Licensing Act, a political press developed. While the Act had been in force, only one official newspaper existed, the London Gazette, published by the government. After its demise, a string of newspapers sprang into being, including the Flying Post, the Evening Post and the Daily Courant. Newspapers had a strong bias towards particular parties, with the Courant and the Flying Post supporting the Whigs and the Evening Post in favour of the Tories, leading to politicians from both parties realising the importance of an efficient propaganda machine in influencing the electorate. This added a new dimension to the Commons' decision to reject 2 new renewals of the Licensing Act in the new parliamentary session. Authors, as well as stationers, then joined the demand for a new system of licensing. Jonathan Swift was a strong advocate for licensing, and Daniel Defoe wrote on 8 November 1705 that with the absence of licensing, one man studies 7 years to bring a finished piece into the world, and a pirate printer reprints his copy immediately, and sells it for 1/4 of the price. These things call for an Act of Parliament. Seeing this, the company took the opportunity to experiment with a change to their approach and argument. Instead of lobbying because of the impact the absence of legislation was having on the trade, they lobbied on behalf of the authors, but seeking the same things. The first indication of this change in approach comes from the 1706 pamphlet by John Howe, a stationer, titled Reasons Humbly Offered for a Bill for the Encouragement of Learning and the Improvement of Printing. This argued for a return to licensing, not with reference to the printers. but because without something to protect authors and guarantee them an income, learned men will be wholly discouraged from propagating the most useful parts of knowledge and literature. Using these new tactics and the support of authors, the company petitioned Parliament again in both 1707 and 1709 to introduce a bill providing for Copyright Act passage. Although both bills failed, they led to media pressure that was exacerbated by both Defoe and Howe. Defoe's A Review, published on 3 December 1709 and demanding a law in the present Parliament for the encouragement of learning, art, and industry, by securing the property of books to the authors or editors of them, was followed by Howe's Some Thoughts on the Present State of Printing and Bookselling, which hoped that Parliament might think fit to secure property in books by a law. This was followed by another review by Defoe on 6 December, in which he even went so far as to provide a draft text for the bill. On 12 December, the stationers submitted yet another petition asking for legislation on the issue, and the House of Commons gave 3 MPs, Spencer Compton, Craven Payton and Edward Wortley, permission to form a drafting committee. On the 11th of January 1710, Wortley introduced this bill, titling it A Bill for the Encouragement of Learning and for Securing the Property of Copies of Books to the Rightful Owners thereof. The bill allowed for fines for anyone who imported or traded in unlicensed or foreign books, required every book that would be given copyright protection to be entered into the Stationers' Register, provided a legal deposit system centered around the King's Library, the University of Oxford and the University of Cambridge, but said nothing about limiting the term of copyright. It also specified that books were property, an emphasis on the idea that authors deserved copyright simply due to their efforts. The stationers were enthusiastic, urging Parliament to pass the bill, and it received its second reading on 9 February. A committee of the whole met to amend it on 21 February, with further alterations made when it was passed back to the House of Commons on 25 February. Alterations during this period included minor changes, such as extending the legal deposit system to cover Sion College and the Faculty of Advocates, but also major ones, including the introduction of a limit on the length of time for which copyright would be granted. Linguistic amendments were also included. The line in the preamble emphasizing that authors possess books as they would any other piece of property was dropped, and the bill moved from something designed for securing the property of copies of books to the rightful owners thereof to a bill for the encouragement of learning, by vesting the copies of printed books in the authors or purchasers of such copies. Another amendment allowed anyone to own and trade in copies of books, undermining the stationers. Other changes were made when the bill went to the House of Lords, and it was finally returned to the Commons on 5 April. The aims of the resulting statute are debated. Ronan Deasley suggests that the intent was to balance the rights of the author, publisher and public in such a way as to ensure the maximum dissemination of works, while other academics argue that the bill was intended to protect the company's monopoly or, conversely, to weaken it. Oren Bracker, writing in the Berkeley Technology Law Journal, says that when considering which of these options are correct, the most probable answer is all of them. Whatever the motivations, the bill was passed on 5 April 1710, and is commonly known simply as the Statute of Anne due to its passage during the reign of Queen Anne. Text consisting of 11 sections, the Statute of Anne is formally titled, An Act for the Encouragement of Learning, by vesting the copies of printed books in the authors or purchasers of copies, during the times therein mentioned. The preamble for the statute indicates the purpose of the legislation, to bring order to the book trade, saying, whereas printers, booksellers, and other persons have of late frequently taken the liberty of printing, reprinting, and publishing, or causing to be printed, reprinted, and published books, and other writings, without the consent of the authors or proprietors of such books and writings, to their very great detriment, and too often to the ruin of them and their families. For preventing therefore such practices for the future, and for the encouragement of learned men to compose and write useful books, may it please your Majesty, that it may be enacted. The statute then moved on to stating the nature of copyright. The right granted was the right to copy, to have sole control over the printing and reprinting of books, with no provision to benefit the owner of this right after the sale. This right, previously held by the Stationers' Company's members, would automatically be given to the author as soon as it was published, although they had the ability to license these rights to another person. The copyright could be gained through two stages. First, the registration of the book's publication with the company, to prevent unintentional infringement, and second, the deposit of copies of the book at the Stationers' Company, the Royal Library and various universities. One restriction on copyright was a cumbersome system, designed to prohibit unreasonably high prices for books, which limited how much authors could charge for copies. There was also a prohibition on importing foreign works, with exceptions made for Latin and Greek classics. Once registration had been completed and the deposits were made, the author was granted an exclusive right to control the copying of the book. Penalties for infringing this right were severe, with all infringing copies to be destroyed and large fines to be paid to both the copyright holder and the government. There was only a 3-month statute of limitations on bringing a case. However, this exclusive right's length was dependent on when the book had been published. If it was published after the 10th of April 1710, the length of copyright was 14 years. If published before that date, 21 years. An author who survived until the copyright expired would be granted an additional 14-year term, and when that ran out, the works would enter the public domain. Copyright under the statute applied to Scotland and England, as well as Ireland when that country joined the Union in 1800.